I'm following on from a topic that Amjad covered at the end of his presentation, which is private law children applications and fact-finding hearings, and when they're appropriate, what should be in the schedule. And what I've observed latterly is that they are listed at an alarmingly high frequency, often messy in terms of allegations and supporting evidence provided, and often focus on parties venting grievances about the failings in their adult relationship. They often have an inadequate focus on the potentially harmful and dangerous impacts on children, both when the parents were together and once the parents have separated. We work in courts where there is a pro-contact approach at the moment, and that means that only very rarely will allegations amount to sufficient to prevent some form of contact taking place. Parents may end up being vilified within the proceedings when they've been acting protectively in the best way they know how, and sometimes the process can then result in the levying of accusations of parental alienation against them, which seems to be becoming more popular and can be quite troubling. Decisions to list fact-finding hearings are often made at an early stage as a recommendation from CAFCAS in their safeguarding letter, and that is at a point at which information available is still very limited, and nobody has had a proper opportunity to scrutinise the genre of allegations and the likely impact on some form of child arrangement in the future. And all that can lead to a huge amount of work undertaken by advocates and a significant amount of court time and judicial time that perhaps could have been avoided. It also adds to increased levels of stress on the parties and potentially unrealistic expectations of outcome by particularly the victim, thinking that if their findings are found, that they may be able to distance themselves considerably from the other party, and that may not be the case. So we have to focus on how it got like this, and I think the first and fundamental is the rather restrictive C1A form that's filled in often by an applicant in person or responded to by a litigant in person. CAFCAS is put in the position of making recommendations based on what's in the C1A and maybe telephone inquiries with parents at a safeguarding stage. Interestingly, whilst I observe that CAFCAS provide a lot of very useful user-friendly guides for their practitioners, which are obviously helpful for us as representatives and advocates to have a look at, there doesn't appear to be any specific guidance to them on when to recommend a fact find, and I have asked contacts in CAFCAS, so I think that is the current position. So the only guidance really is that they need to fulfil PD 12J paragraph 9 and articulate why they recommend fact findings and relevance to the children. We then come to the Scott schedule, which I found comes in many shapes and sizes, as many as there are species of plant in a horticultural show, and some of them are pruned or cultivated at the direction of the judge. Format of the Scott schedule is going to impact on its usefulness in any particular case, but has the potential to limit the case to the client's detriment. So great care needs to be undertaken when preparing them. Very rarely have I seen them identify how the behaviour complained of has impacted on the children or may impact on them in the future. And that is actually essential when you look at PD 12J paragraph 29, which requires the court to make findings of factors of the nature and degree of any domestic abuse which is established and its effect on the child, the child's parents, and any other relevant person. We tend to find that they're very parent orientated. One difficulty with Scott schedules, which is becoming more and more apparent as we identify more types of domestic abuse, is that when the court focuses on specific allegations and makes determinations about them, the court may have lost the opportunity to get a broader flavour of the dynamic of the family, which is at the heart of the decisions to be made in relation to how each party will participate in the relationship with their children moving forward. And again, that is framed in PD 12J paragraph 35. PD 12J itself is something that's highly relevant to this situation. We all know it exists, it's lengthy and it's cumbersome. And my best advice is have a look at it in full and use it to prepare a handy sort of pro forma guide for yourself that you can pull out whenever cases look like they might be turning into fact-find cases. Paragraph 19 is particularly useful for that. And with that aid memoir, you can properly take stock of and revisit, should your schedule be refined, or in fact, should the court not be constrained to a schedule but hear wider evidence? What are the responses to allegations and the response statement? Is it adequate? Should there be a split hearing? Skeleton arguments from parties on whether there should be a fact find at an early case management stage can be a very useful tool to focus on what's really relevant to the ultimate determination of what is in the best interest of the child or children and the safety and management of them and the parties in the future. PD 12J paragraph 7 reminds us of the presumption that the involvement of a parent in a child's life will further its welfare unless there is evidence to the contrary. There definitely seems to be a developing shift to focus more on the understanding of the totality of the family dynamic when decisions are being made about children and their parents after relationship breakdown. And I would recommend you take a quick look at the Ministry of Justice publication from June 2020, the assessment of risk of harm to children and parents in private law children cases. It's a long report, but if you go to the end and look at the recommendations, it gives you quite an insight into how things might change in the future. I'll also draw your attention quickly to the case of FVM 2021 EWFC 4, a judgment published on the 20th of January, which you might have seen appended a link to the footer of our communications from chambers, which deals with the issue of coercive control and consideration of its appropriateness or use of Scott schedules in cases where coercive control is being considered in private law. And just to finish off, the devil is in the detail. There are significant benefits in front loading your preparation at the outset, getting instructions from the client through, recapping over everything and getting those minute by minute details from them of the events surrounding allegations. Then you've got early, fair and frank management of the client's expectations, presenting a case which has a good prospect of achieving the outcome you've indicated to your clients possible, endeavouring to achieve a timely conclusion, keeping matters proportionate, and managing the client's stress and anxiety to enable them to participate to the best of their ability in the process.